Mr. Justice Devendra Kumar Upadhyay, Chief Justice, High Court of Delhi, Mr. R. Venkataramani, Attorney General of India, Mr. Justice U. Lalit, the former Chief Justice of India, brothers and sister judges, retired judges from the Supreme Court and the Delhi High Court. It's always a pleasure to come back to Delhi High Court, my parent High Court. And I see amongst the retired judges Justice Prasad, before whom I had occasion to appear and argue both texts and one big criminal matter, which was a test case for me. It's always a great pleasure to stand. It's a great pleasure and honor to stand before you at the launch of Ratanlal Dhirajlal's Raw of Crime, a comprehensive commentary on Bharatiya Nyaya Sanhita 2023. Is perhaps the first comprehensive book on Bharatiya Nyaya Sanhita 2023. But what makes this occasion very special is this synergy of two incredible names. It's an amalgam of the present, that is Justice U. Lalit, an exceptional criminal law expert and the gold standard of legacy of Ratanlal and Dhirajlal. When I walked up, I met Justice U. Lalit. The first question I asked him, how did you find so much time? And weren't you overawed at the very thought of writing a book? He said, yes, it was a challenge, but he liked it and therefore he took it up. I'm sure we all will be proud of the efforts. He'll be proud of the efforts which he's put in, and we'll be all benefited by the effort which has gone into. Justice Lalit stands amongst India's legal criminal law experts with combination of experiences spanning advocacy and adjudication at the highest levels. There is hardly a political party or a political leader he must not have represented, or even as a prosecutor, prosecuted political leaders. He belongs to the rare category of legal minds who has excelled equally as advocates, scholars and jurists in our legal fraternity. His influence on our criminal jurisprudence runs deep, and his involvement on these commentaries adds immeasurable credibility and insight. Coming back to the gold standard, I must confess, when we joined law faculties to study the 3-year law course, we used to go around looking around for finding a commentary by the name of Ratanlal Dhirajlal. Ratanlal Dhirajlal. It was always in short supply. For some reason, either it used to be sold out immediately or it was out of print. And if you could get a copy, it would be a prized possession. Everybody will search around and look around for it. But that was early 80s. Come 1990s or late 1990s, I had my first experience with what we know now is online or software textbooks or just software journals. I had purchased my first software tax journal as an Income Tax Standing Counsel way back in mid-1990. It was called Tax Expert, and it was a big boon at that time. Nobody would have heard it. There was no SEC Online, no Manupatra, no Apex, nothing like that at that time. But then I have over the years realized that as technology moves, we cannot give up on physical textbooks. These are our standard requirements for any lawyer, even for that matter, a student. For the judges, it's indispensable. We cannot do without the commentaries, which are far more detailed, far more comprehensive, give a much more 360-degree view of what it is. So unlike some who suggest that in today's digital era, with instant access to cases and statutes, comprehensive commentaries have become less essentials, I beg to disagree. It's precisely the opposite. Perhaps we require commentaries more these days because there's a tendency just throw up case laws. Judgments also reflect that. They throw up case laws. Judgments cannot be thesis. Judgments cannot be commentaries. And if one looks at the judgments which we rely upon, these judgments rely upon commentaries. So why not go to the basic? That is a commentary. I hope these volumes will continue with the legacy of excellence, maintaining the methodological analysis and practical utility that made their predecessors indispensable. We also sometimes undermine the importance of criminal law on the society. When I look at the law students, new entrants, many of them do not want to take up criminal practice. The fact of the matter is, most of the litigation in the district courts is criminal litigation. The fact of the matter is, criminal law is incredibly vast and holds a singular place in our legal workforce. It directly impacts individual liberty, social harmony, and the fundamental balance between state power and personal liberty. These laws authorize arrest, detention, and deprivation of liberty, concrete powers that affect citizens' life daily. We should not, therefore, ignore the importance of criminal law, and I hope and trust that many youngsters, including lawyers, will gradually join criminal law as a first choice rather than as a second or compulsion when you have to deal with when you join the profession. I must also share with you, when I joined the legal profession in 1983, I had no liking for criminal law. I had no vision about criminal law at all. At that time, there were no white-collar crimes as today, so possibly lawyers were not attracted. I went into criminal law, a very niche branch of criminal law, income tax taxation, income tax prosecutions, for the simple reason criminal lawyers won't understand the income tax law and income tax lawyers won't understand the criminal law. So both of them were afraid. So it was a good field for me to join, and that's where I gained my first bits of criminal law. The second exposure which I had was a short stint for about 2 years as additional public prosecutor in the Delhi High Court, where I did defend the state and also appeared as amicus curiae in some cases where I appeared for the convicts who had filed appeals. And I succeeded in quite a few matters. And I was once surprised when the convict came over to my house and said, "Thank you." That was something quite experience which left me satisfied that what criminal law or a criminal lawyer earns, you can never earn as a civil lawyer or even as a constitutional lawyer at times. One thing I want to emphasize is that this is an era of super specialization across disciplines. So same is with the criminal law. But most laws, especially the criminal law, must be based upon empirical foundation. Increasingly, we have embraced evidence-based approaches while drafting and also deciding cases. Principle of proportionality, which is applied several times by us, even in constitutional benches, is primarily based upon data and empirical evidence. This is something which is not being taught in the law schools. It's not been addressed even today. Criminal jurisprudence, I believe, in future would not rely upon untested assertions about behavior and social dynamics. It will increasingly rely upon data. Data exists, data speaks, analytical tools exist. What we need to do is to let evidence drive the criminal law forward. The last aspect is perhaps a request to the publishers. Make the commentary accessible to everyone. Thank you.